Welcome to Medmarc's webinar series. Today's presentation is titled AI Litigation Risks for the Medical Technology Industry. I'm Kate Klaus, Senior Attorney in Medmarc's Risk Management Department. On behalf of Medmarc and today's presenters, Jenny Colgate and Jennifer Maisel, thank you for joining us. Jenny Colgate is an experienced litigator and advisor. Her practice is largely focused on litigation and extends into all facets of intellectual property and technology-related matters, including patent, trade secret, data protection, unfair competition, trademark, copyright, breach of contract, and fraud claims. In addition to litigation, Jenny regularly handles a wide range of other legal matters for clients. She's skilled at pre-litigation risk evaluation and strategy and counsels clients on IP protection and enforcement, as well as privacy law compliance and best practices. Jenny also advises clients in contract and licensing matters such as negotiation, drafting, IP and privacy issues, and dispute resolution. Finally, she's a recognized thought leader, authoring expert analyses, speaking on panels and webinars on topics as diverse as developing IP issues, litigation strategy, damages and remedies, and privacy. Jenny has a BA from the University of Pennsylvania, an LLM in intellectual property from the University of New Hampshire Franklin Pierce Law Center, and a JD from the University of New Hampshire Franklin Pierce Law Center. A highly skilled strategist and thought leader, Jennifer Maisel focuses her practice in an exceptionally challenging area of intellectual property law and litigation concerning rapidly evolving digital technologies with a focus on artificial intelligence. Jen has technical experience developing language models for natural language processing applications and has been helping clients navigate through their IP, data protection, and privacy concerns in the AI space. For large corporations and emerging companies, Jen also routinely represents clients with breakthrough innovations in virtual reality, big data, the Internet of Things, privacy, cybersecurity, quantum, and blockchain technologies. Jen has represented dozens of clients in intellectual property litigations in district courts throughout the country and at the appellate level before the U.S. Court of Appeals for the Federal Circuit and the U.S. Supreme Court. Jen counsels clients in a wide variety of industries on identifying, procuring, and licensing valuable intellectual property rights, including patents, trade secrets, copyrights, trademarks, data rights, and open source open data. Jen is registered to practice before the U.S. Patent and Trademark Office and counsels clients as to the scope, validity, and enforceability of rights of existing patents. She has a BS in Information Science, Systems, and Technology with a specialization in Operations Research and Information Engineering from Cornell University's College of Engineering and a JD from the George Washington University Law School. And with that, I am pleased to turn things over to Jennifer.
Kate and Heather, thank you so much for those introductions. And Jenny and I are so thrilled to present on this very important topic of the day. Before we dive in, I just want to give a quick disclaimer that Jenny and I are lawyers and we are litigators, but the advice herein should not be considered legal advice specific to your situation, it's general information. So with that, I'll turn to our presentation. At a high level, we're going to talk a little bit about artificial intelligence and how it has permeated the medical technology industry. And then we're going to highlight some of the key considerations for MedTech as it intersects with artificial intelligence, looking at the deployment, use, and training of artificial intelligence systems, and then dive into some use cases and examples of how parties have gotten into trouble on the litigation front. And hopefully some of you out there can avoid many of these pitfalls. So with that, just turning to our first topic, what is artificial intelligence? And you've probably seen a million different definitions by this point. I have one up on the screen here from the Food and Drug Administration, the FDA. But there are a couple of key points I want to highlight from this definition and maybe what we think of more broadly as artificial intelligence. First off, when we think about software historically, there's a lot of focus on code and how do we program systems to do specific tasks. I'm a software engineer by training, and we would write a program and we'd specifically program that code to perform a task. unlike traditional software programs that are a little bit more static. They're predictable. You know what happens when you put in an input. The input goes through your algorithm and out comes an output based on things that you explicitly programmed into that algorithm. By contrast with artificial intelligence, some of the key differences between AI and software more traditionally is that AI isn't specifically programmed to perform specific tasks. Instead, we more generally program artificial intelligence systems to learn how to perform a task. This is where you may have heard of phrases like you're training an AI system, or training an artificial intelligence system to perform a specific task. Maybe it is recognizing certain pixels in an image and classifying those pixels. Maybe it is interpreting speech. Maybe it is making other types of decisions, but we are training a software program to learn how to do something rather than explicitly programming a certain functionality. And some other key things that make AI a little bit different from our more traditional software is how it adapts over time. You've probably heard of phrases like the algorithms, the machine learning models can learn, meaning that they may change over time. And this comes more from a subset of artificial intelligence called machine learning, which is, there are many definitions of machine learning, but effectively, we're talking about the use of typically large quantities of training data, feeding that training data through an algorithm. And based on the example shown in that training data, an algorithm learns how to pull out different correlations, different relationships, and is able to learn from that data in order to see a new data point, and based on the training data it was exposed to, interpret that new data point and provide an output based on the things it learned from the data it's seeing. So from that data, we might be learning. So as you get a new data point and maybe receive feedback from a user or a human trainer of the system, the algorithm is designed to learn over time and get better and better at the specific task that it's doing. At least in an ideal situation. Sometimes models drift and they start getting less accurate, but ideally we want learning over time to improve the model. There's also some decision-making and predictive aspects of machine learning that, again, it's a little bit hard to predict, but the earmark to think about with AI is these systems do adapt and change over time compared to traditional software engineering where you write a program and that program tends to be fixed until a human goes in and updates the code.
So we thought before we get into some of the law and the legal risks with AI in medtech, it might make sense to walk through how AI is used in the medtech industry, because that will provide sort of an example of then what claims might end up resulting from that use. So the first is drug development. And you can think of, how Jen was explaining that AI is sort of unpredictable outcomes based on training data. You can reduce the number of lab experiments and you can predict results. And so you can actually speed up the development of drugs. And it was pretty exciting. Earlier this year, there was news about a pharmaceutical company in Hong Kong that for the first time used AI to discover a target and also to generate a design for a drug. And that drug is to treat idiopathic pulmonary fibrosis. And it's currently undergoing clinical trials. So that's pretty exciting. And it's, kind of the first instance of AI being used for drug development. You also have software in a medical device. So you can think of this as software being used to kind of assist a medical device that already exists. So maybe it's, radiology, and the AI is being used to draw a box around something that might be a problematic area, just is likely to be cancer. Or you can have an AI-enabled prosthetic, which is reading the data from the residual limb muscle and using that to actually control the prosthetic and make for a better prosthetic. You also have AI-assisted surgery, which can do visual overlays and help a physician do more efficient and more perfect surgery. Another example is software as a medical device. And a lot of times this is like an app, for example, where the software itself is the medical device. And so there's a lot of mental health applications that exist now where they monitor cell phone usage and can actually, based on the data that's being collected, predict a depressive episode and potentially trigger loved ones, send messages to loved ones. Similarly, there are apps for Alzheimer's and dementia that can be used to predict, like cognitive health abilities and if there's a risk of, dementia or something like that. Then moving on to the second level on the screen, there's software used to manufacture a medical device. And here it's a matter of AI being used to maybe predict the supplies that you would need so that you don't either overestimate or underestimate your supplies. You can use AI to actually fix problems in your supply chain or make the supply chain more efficient. So all sorts of things within the manufacturing of medical devices or any kind of manufacturing for that matter. You also have AI being used to speed up medical discoveries. So Google has a company called DeepMind, and they made the news recently because they were able to actually predict the structure of almost every cataloged protein out there, which is over 200 million proteins. Meanwhile, you had humans working for years to only determine the structure of a few proteins by comparison. So, the amount of development that can come from speeding up these medical discoveries is amazing. And then finally, it's not on the screen, but you also have AI being used to aggregate data across health systems. And so that's something we might be talking about some more later too.
Thanks, Jenny. Bottom line, there's so many use cases of AI in the medical technology industry. It's really incredible. So just the 10,000-foot view, honestly, we could give a whole other separate hour-long presentation just on regulations around AI, but we want to contextualize some of the sources of our laws and enforcement powers that we need to be mindful of when we think about litigation risk. So starting at the top, we have executive orders at the federal level, as well as federal and state regulators that have been issuing guidance and rules concerning AI systems. Recently in the headlines, we've seen a lot of activity concerning bias and algorithmic discrimination. The White House recently issued an AI Bill of Rights. There's been a lot of activity around how do we make AI systems safe and effective for the consuming public, especially now, more recently with a lot of really powerful AI tools now in the hands of everyday consumers. So a lot of regulatory activity, and we'll get a little bit into some of the FDA guidance as well as Federal Trade Commission enforcement actions to be mindful of. Stepping on, there's then legislation. So what laws exist out there concerning regulation of AI? Currently, we don't have an omnibus law about regulation of artificial intelligence. By contrast, over in Europe, some of you may have heard about the EU AI Act, which has several categories of regulation around AI systems that's going to be applied more broadly. Instead, what we've been seeing in the US, at least so far, are really narrow laws targeting specific abuses or potential abuses in industries. So for example, discrimination in the employment and hiring context, safety regulations about the rollout of autonomous vehicles. Interestingly, Nevada was one of the first states back in 2011 to create almost a regulatory sandbox for testing of autonomous vehicles. So there's been this interesting balance between regulation and innovation and giving companies the space to innovate while again targeting the most egregious harms. Bans on facial recognition technology, especially in the law enforcement context. Some of you may be familiar with the Clearview AI litigation and how Clearview AI was alleged to have been scraping a lot of public data, a lot of faces from social media, and using that to train systems used by law enforcement agencies to identify suspects and other targets of interest using facial recognition technology. And several jurisdictions have issued outright bans on that technology or precluded sales of that technology to law enforcement absent specific safeguards in place. There have been some recent laws in the insurance context and the use of AI to automate certain policy-related decisions, as well as there are laws concerning deepfakes. Deepfakes has been a really popular topic if we think about the election coming up and the potential for misinformation and disinformation campaigns, as well as other privacy abuses involving people's image and likeness. And then finally, what we're focusing on here, litigation of disputes. So how private parties litigate disputes in federal and state courts throughout the US and what precedents we can draw from that. Again, very high level here, regulation of AI, a couple key points to keep in mind. 2019 executive order, maintaining American leadership in AI. This executive order jump-started a lot of initiatives that we've seen at the federal level in terms of investment in AI systems, continued regulatory focus, an outline of 10 principles and binding and non-binding principles to follow in terms of the government's adoption and use of AI systems. And again, we've seen a lot of focus on the balance of the needs for innovation with AI and the need to have safe and effective systems out there. Two things to really keep in mind. One is earlier this year, the National Institute of Standards and Technology, NIST, they released their AI risk management framework. And it provides a very helpful roadmap, I think, for companies out there in any industry, including the medical technology industry, for using in trying to identify risks. And I'll get a little bit into that AI risk management framework on the next slide. But that's been a key tool. Many of our clients have been using the NIST AI risk management framework to identify and explore risk and mitigate against risk of AI so that we can avoid litigation. And more specific to the medical technology industry, on April 3rd, 2023, earlier this year, FDA released a working document, marketing submission recommendations for a predetermined change control plan for AI ML-enabled device software functions. And again, thinking back to our definition of AI and former pre-market approval, traditional software systems are fairly static. You write the code and it doesn't change until a human goes in and updates it. By contrast, and it's recognized by the FDA, when we're talking about the integration of machine learning and other AI technology into medical devices, that the software itself may actually change over time. And the FDA is looking at how to best address those changes and identifying decision points and points in the development life cycle and release cycle to which you need to update your disclosures. So just briefly on the NIST risk management framework, a really great tool for those out there who are deploying and using AI systems. The overarching theme is for any enterprise, you need a governance structure around AI. And as part of that governance structure, setting up a team with the appropriate stakeholders and the appropriate expertise to implement the following functions: map, measure, and manage. So mapping is identifying where AI is used throughout an enterprise, used in products, things like that. Measure, think of that as testing your use of AI systems, deployment of AI systems, development of AI systems, to ensure that they are not producing output or are being used in a harmful way, how can we quantify, for example, bias or discrimination in automated tools out there? And then the third aspect here is manage. Once we identify the risk and the problems, after we've mapped and measured them, how do we manage those risks? What safeguards do we need to put in place? So then just thinking about the overview of AI litigation risks, as we see things up for potential litigation and things go wrong. There are three buckets that we've identified. One is the use of training data. Second is deployment of AI systems. So the development and deployment of AI systems, how they're launched to the consuming public, and then the use of AI systems. And Jenny, do you want to expand on this?
No, I think we can get into that on the next slides. So this is just sort of an overview of what's going to come in the rest of the presentation. We'll overview, sort of those three buckets that Jen outlined, and then get into some examples of specific legal claims that you can expect with AI litigation. So the first of the buckets is what we call radioactive training data. And the reason we're calling it radioactive training data is we want you, when you hear training data, to think, high risk. This is scary. I have to really think this through. Because one of the biggest areas that we've seen causing litigation risk with artificial intelligence is the training data. And on this slide, we have a couple of buckets of potential risks that come with training data. And so the first of those is personal and sensitive data. This kind of falls into the privacy bucket. And the big issue here is, did you provide users with notice that you would be using that data to train AI? Or if you didn't, did the person who was collecting the data provide the notice? You can't go back and provide hindsight notice. You'll get in big trouble for that. And you have to make sure that the notice is clear. You're going to have a lot of cases and a lot of litigation, I think, on sort of vague notice. And was that sufficient notice? You also have a lot of privacy policies now being clarified. How does that clarification affect a determination on whether the prior notice was sufficient? So I think we'll see a lot of cases on this. And then also authorization. So just because you provide notice, is that sufficient? Do you actually have to have the user, give express authorization, allowing that data to be used to train AI? And whether you need authorization will depend on, the laws and the regulations that exist. It will depend on the contracts. So you really have to go through, all of the different things that you have to comply with and determine if you need that express authorization. And then another thing to think about is just sort of best practices and, your relationship with your customers and stuff like that as well. To what extent do you want to do something even if it's not legally required? And then the next bucket is your third-party IP rights. And so a lot of what falls into this bucket, you'll think of in terms of, you've heard about, artists and musicians, and they're concerned about their data and their works of art and their creations being used to train artificial intelligence. And is that fair use, or is that permitted? Or is that a violation of copyright? But you can also have instances of copyright violation with MedTech. For example, if you're using code and software to train an AI system and generate other code, like that could be a potential IP, third-party IP issue with training data. So just because it's MedTech doesn't mean, don't pay attention to third-party IP rights. You should absolutely evaluate that as well. The third bucket is your contractual limitations. And here, a lot of what's making the news right now is the way that OpenAI was trained and the scraping of data, and whether that scraping of data violated terms of use for websites. So that's something you want to pay attention to. If the training data was scraped from websites, what were the terms of use on those websites? Did they permit scraping? But in addition to that, even if you aren't using training data that was scraped from websites, say you're using training data that you had access to because of some sort of contractual relationship, but it didn't necessarily anticipate use in AI, is that going to run afoul of your contractual rights? So you want to go back and really look into whether you have the right to use the data that you're using to train the AI. And then the final bucket is, you might think, well, if I've got AI and the data is being purchased from a third party, I'm not actually the one out collecting and scraping and putting together the data, I'm good. And not necessarily. You want to go and look at your contract again for how you're getting that data, look at representations and warranties. It'll be interesting how the law develops on this with there's like bona fide purchaser for value law that could very well end up applying in that situation. And so we'll end up seeing litigation on training data that's purchased as well in the future, I think.
So switching gears a little bit. So thanks, Jenny, for talking about the radioactive training data. In addition to training, just thinking about the development and deployment of AI systems. So if you, as an enterprise, are releasing a product that has AI-enabled functionality in it, we have up on the screen a couple of potential risk mitigation strategies to employ when, as part of development and deployment of these systems. I have, in the first bucket here, the NIST AI risk management framework. It doesn't have to be the NIST framework, but our advice generally is, if you're developing an AI system, be sure to look to industry standards of what is required as part of the engineering and development of these systems. Do you need a red team and really test your system before it's deployed? What other standards of care are there in terms of development and testing of artificial intelligence and software systems more broadly? Some of these themes can be taken from the cybersecurity context, and thinking about what are reasonable security measures we can take for our software and digital systems. Similarly, for AI, what can you do internally? Can you point to a practice and a standard that you have been following as part of your development? Another point is this idea of a human in the loop, or a human gut check on automated decision-making. And depending on the application, this is or isn't always an option, but some enterprises run into trouble where they just let an AI system run wild, and there's no human oversight, no gut check to say, hey, does this output make sense? Is it accurate? Is it being used for its intended purpose? This is especially important when we think, maybe from the consumer context of some of those large language models out there. When they hallucinate, when they just start making up facts, are there known risks and biases in their systems where sometimes we're going to need human oversight? Or maybe there's an impactful decision. Maybe we're talking about a real-time decision-making in the medical context. Operating on data in real time. Do we want a human physician or another healthcare practitioner to look at the data, look at the output and evaluate it before just automatically making a decision that may affect someone's life? So just having that human in the loop. The third bucket here, warnings and disclaimers. We don't want to hide when there's automated decision-making at play or AI software at play. One thing that we've seen in the regulatory context, and there's some proposed bills out there on the legislative front of putting warnings and disclaimers out there when there's an AI system being used in a high-risk industry. Private parties are doing this as well. If you've ever read the terms of service of some of the popular software tools out there, a lot of times there are disclaimers saying, this system should not be used to provide medical advice. This system should not be used to provide legal advice. Please take care to, know the limitations of the system and warn the end users, the patients, the customers about the limitations of an automated system that uses AI. More recently is the labeling and watermarking of AI synthesized content. This comes from a lot of the disinformation concerns out there about hallucinatory content, the people out there that are building content farms and things like that. But this could come up in the medical context. Say that an AI system is augmenting some kind of scan or augmenting something in real time, maybe a display, or you can think about an augmented reality or virtual reality system. We want to make sure that we're clearly labeling synthesized content from a human engineering perspective, as well as just a disclosure requirement. Make sure that the AI synthesized content is clearly labeled and disclosed. And then finally, this one's really important to think about edge cases and product liability concerns. And there are a couple of ways to think about these issues. AI systems, by and large, they tend to be really good at what we would call the usual case. So when in the medical context, maybe we have a typical patient where 95% of the time, based on a set of symptoms or data, there's one outcome. But what do we do when there's an edge case? And sometimes AI systems perform quite badly when there's an edge case. We can think about sometimes deadly examples of this when we think about autonomous vehicles, not being able to identify a white semi-truck in front of them. There are other dangerous situations out there. What happens when there's an edge case? Another way to think about this, and this is also from a PR perspective as well, what happens when our AI-enabled device makes a mistake that a human never would? How do we get around that narrative and those liability issues when these automated systems make mistakes? And again, thinking about edge cases and building in some of these checks, like the human gut check and the human in the loop, may substantially reduce some of these risks. So finally, there's the use of AI systems that can pose significant litigation risks. And outside of just the medical tech context, but thinking about what your company does internally, what are your employees doing with AI systems? How are they engaging with them? And we have on the screen here to beware of open or public AI systems, as opposed to enterprise systems where you have a negotiated agreement in place that covers your enterprise's use of an AI system. A few months ago, a couple of unfortunate Samsung employees made headlines because they leaked highly sensitive source code to ChatGPT and trying to use it as a tool to generate source code for the company or validate source code. And unfortunately, with some of these public systems, you have to really dig into the terms and conditions. You have to understand how these models work in order to evaluate the potential risk of using these systems. One of those risks being the leakage of sensitive company data out in the public. And sometimes, again, there are interesting terms in some of these terms of use. Maybe there's a restriction on what you can do with the output from some of these AI tools. There are even open questions right now that from a policy perspective that the US is dealing with in terms of if a machine generates output, who owns that output? Is it patentable? Is there a human inventor involved? Is it subject to copyright protection? Can a human actually claim authorship over that machine-generated work? So there are lots of risks in terms of the use of AI systems, and thinking back to the NIST AI risk management framework, having a culture of governance and oversight within an enterprise over the use of AI systems will help you identify and mitigate against those risks.
All right, so piggybacking sort of, we just went through some of the facts where you might end up in litigation with AI. But now what we're going to do is kind of turn and look at it from a different direction. And so this is examples of claims, legal claims, that you might see for AI-related MedTech litigation. And what might surprise you is when you look at this, and these are examples, there's other claims too that I'm sure will end up getting asserted. But what might surprise you is that these look like just very basic areas of law. I mean, for those lawyers that are on the webinar, these are, you know, the same areas that you might have studied in law school. They're pretty broad. There isn't, you know, breach of AI law, and we don't have an AI law. And maybe there's a question of should we? It's interesting because in reading on this and listening to a lot of thought leadership, there's a lot of references back to when cyberspace was new. And there was discussion on should we have a law of cyberspace and cyberspace claims. And there's a famous Judge Easterbrook from the Seventh Circuit who said, you know, that we don't need a law in cyberspace, just like we don't have a law on the horse, that we have these great, very old areas of law, these buckets that have existed forever. And all we have to do is figure out how that law applies to the new facts. And you can use old facts that have existed and make analogies between those old facts and, in this case, artificial intelligence, and figure out where the law should go. And there will be variation. You know, I'm sure some district courts and some circuits will go one way and some will go the other, but it will all get worked out, and it's just sort of the common law tradition. But, you know, I think we'll be fine. And so what we're going to do is we're going to walk through each of these buckets that you see on the screen and talk about, you know, how the law will apply, AI cases that we've already seen, and in some cases, kind of where we think the law will go when applied to artificial intelligence.
Thanks, Jenny. So I'll handle these top 4 causes of action and just contextualize how these things might arise in the MedTech industry when we're interfacing with AI systems. So turning first to breach of contract. Jenny mentioned this before with radioactive training data, but breach of contract claims occur when you fail to abide by third-party agreements, and notably website terms of service. We have one example up on the screen. It's HiQ Labs versus LinkedIn. Here, HiQ Labs was scraping lots of content from LinkedIn in violation of LinkedIn's user agreement that forbade scraping and following, spidering the server. And this issue went to summary judgment, and LinkedIn stated a viable claim for breach of contract. And thinking about the MedTech industry and how this might come up, you know, we have to think, are there any agreements in place we need to think about in terms of how we're getting our data? If you're collecting it yourself, whether it be web scraping or other means, what agreements are in place that may govern the collection of that data? If you're licensing data from third parties, is there an agreement in place that puts restrictions on what you can and can't do with that data? Again, as Jenny mentioned before, maybe you have old agreements with companies about data exchanges and permissible uses of that data. Do those permissible uses cover, you know, using that data for the development of AI systems? If not, do we need to renegotiate that license and think about different compensation? Are there downstream agreements with suppliers and manufacturers that restrict their use of sort of data relating to AI. We have to think about what contracts are in place. And unfortunately, there are a lot of contracts when we think about AI systems between all the counterparties involved. Another important point to note, I mentioned terms of service before and restrictions on output. If you are incorporating third-party technology into your product or leveraging open source models, you need to keep in mind what agreements are in place, whether it's an open source license, an open data license, or maybe a proprietary license in terms of what you can and can't do with that third-party technology. So, for example, maybe you can't leverage certain models out there for providing medical advice absent a specific agreement to the contrary. Again, copyright infringement, thinking about radioactive data. Jenny had mentioned one example in the MedTech industry, which is the use of open source software to develop some of the machine learning and AI applications out there. And I have up on the screen just a couple of the pending litigations out there right now concerning the third-party use of a company's proprietary and copyrighted works to train an artificial intelligence system. And the open question of the day is training an artificial intelligence system on copyrighted material excused fair use of that copyrighted material such that there's no copyright infringement liability. And it's an open question that's being litigated today. But one area where this may come up is if we're thinking about the code generators out there and the use of open source tools and data in an AI model, again, is that training a fair use of that protected content or not? And we're going to find out one way or another whether the litigation or rule changes. I don't want to predict the future, but it is going to be an interesting area to follow. But, again, in the medical technology industry, again, thinking about all the ways that your data may be radioactive. Patent infringement, some of you may be familiar with patent infringement disputes. They're not AI specific. I think one of the hallmarks of a successful company is once you're out there and you have your product and it's approved or exhibiting a lot of commercial success, then come the patent infringement claims and lawsuits. And I just want to put on your radar that medical technology is an active area of patent enforcement. And one thing to keep in mind, there's always a tension when it comes to AI technology in terms of how to protect it. Do we keep that AI technology a trade secret? Or if we have to publicly disclose that AI technology and how it works and some of the parameters that we're using, maybe, for example, as part of an FDA approval process, we may want to think about patent protection. And there are a lot of considerations in thinking about what type of protection we seek. And I have two cases up on the screen. Unfortunately, patent eligibility issues have come up when it comes to software in medical devices and whether that software is directed to a patent eligible technological improvement to the underlying product, or if it's just simply an abstract idea that's unenforceable. So just something to keep in mind in terms of your IP protection as an asset and how to leverage it in terms of patent infringement claims. And then unfair competition. Be careful when it comes to evaluating and potentially reverse engineering competitors' products out there. And the case up on the screen, Philips North America, the defendant here was obtaining allegedly falsified certificates to access Philips software. And as you can imagine, this caused a lot of issues, a lot of claims involving circumvention of a technological control under the Computer Fraud and Abuse Act, theft of trade secrets, breach of contract. And you just need to be mindful that there's a whole group of unfair competition laws out there that generally address business conduct that is contrary to honest practices in industrial or commercial matters.
All right. The next bucket is the data privacy litigation. And a lot of this piggybacks on what we talked about earlier. So in the interest of time, I'll jump over some of it, but it's interesting to point out the PM versus OpenAI case, just because I think it's a really good resource to look at if you're wondering what types of claims could possibly be asserted with respect to the radioactive training data. And you know, some of the claims, for example, were the breach of terms of service, like we talked about, privacy law claims, both state and federal. Some of these were related to wiretapping. Some of them were related to children's data. There was a Computer Fraud and Abuse Act claim, which dealt with the unauthorized access of a computer, you can use a computer to access information that's beyond your control, beyond your permissions. And then there were also a number of common law privacy claims that were asserted, which was interesting, like invasion of privacy, intrusion upon seclusion. So if you want kind of a good overview of possible claims, take a look at that complaint. Another thing to think about with data privacy litigation and artificial intelligence is it's worth reconsidering on a somewhat regular basis if data that you didn't consider to be personal is now personal in view of AI. We have, better computer systems, we have better algorithms. There's so much data out there that it's a question that you can't say, oh, we resolved that, we're done, we never have to revisit it. It's something that you'll want to continue to revisit. The next slide, we deal with biometric information. And so with data privacy, a big area that's getting a lot of attention because of the heightened sensitivities is biometric information, which we think of traditionally as face scans and fingerprints and DNA data. An area that gets a lot of attention is Illinois' Biometric Information Privacy Act. And the reason for that isn't because it's unique in that it's a Biometric Privacy Act, because there are others. It's unique because it has a private right of action, and it's a Biometric Information Privacy Act, and it's the only law currently in effect, although that's going to be changing, that is the combination of those two things. And so what happens is, like, just, I think it was earlier this year or late last year, there was an over $200 million verdict because people entering a railway were getting fingerprinted. Their biometric information was being collected, but they didn't provide express authorization to allow the biometric information to be collected, and the damages accrued per fingerprint. So as you can imagine, that escalated greatly. That might be a big concern for people in the medtech space, but there was just recently this year a really interesting case. So there's a HIPAA carve out for BIPA, but in addition to that, there's an additional carve out for information captured from a patient in a healthcare setting. So you have a HIPAA carve out plus information captured in a healthcare setting. What does that mean? And there was a case in an Illinois federal court just earlier this year. The decision came out that it was against Christian Dior, and they had face scans, and you could try on non-prescription sunglasses. And they didn't seek authorization to do the facial scan. So there was an alleged violation of BIPA. And it was determined that even though it was non-prescription sunglasses, it fell in that information captured from a patient in a healthcare setting. And so there was no violation. So that's really good news for medical devices with respect to BIPA. That could potentially be really bad news for application in other privacy laws, because how big is information in a healthcare setting? And we'll talk in a minute about a different law where it could be bad news. One other thing to point out for biometric information is the FTC recently issued a biometric information policy statement that just is warning about the increasing use of this information. And so you should be aware of use of it in general, provide notification, get authorization. You should also be aware of it from a bias and discrimination standpoint. And you should, if you're using that information, know that it's an area that the FTC is looking at very closely right now. Turning next to the Washington My Health, My Data Act. So this is the law I was talking about. This is a new law. It's coming out in 2024, and it regulates the processing of health-related data outside of HIPAA. And it's really, really broadly defined. It expressly includes information that is inferred or derived. So it expressly includes information generated from artificial intelligence. You can think of it that way. It has a private right of action, but unlike BIPA, where it's kind of a little bit narrow of a private right of action, this is a really broad private right of action. There's a number of rights, and the private right of action can be used to assert a violation of any of them. Access, withdrawal of consent, requested deletion of data, you name it. And so an example that I like to give that I think of as potentially scary and something that could end up in litigation is if you had information, you gave consent, it was used by a medical device, say, to generate, artificial intelligence, generative AI, more and more stuff is generated. A year down the road, you say, you know what? I'm going to assert my right to delete it. I want it deleted. Well, it's generative AI. At this point in time, as far as I'm aware, it's potentially impossible to delete everything that was generated from it. But under Washington's My Health, My Data, you have a private right of action to enforce it, and you have a right to have it deleted, including information that was inferred or derived. So what happens? I think that's, we'll see. It goes into effect next year, and I'm sure there'll be litigation similar to that we see. Turning to the next slide, I'm going to try to speed it up a little bit in the interest of time. There's a lot of FTC enforcement action about the unauthorized sharing of customer data for advertising. And so these are three examples. GoodRx was a prescription company. So they collected data on people's prescriptions and healthcare information. They told customers they weren't sharing it, but they turned around and shared it with Facebook and Google, a bunch of other companies. So the FTC enforced for the first time the health breach notification rule, which had been in effect for, I think, at least a decade, but it had never been used before in an enforcement action. So it was enforced there, and it came with a $1.5 million penalty, bunch of other conditions, obviously on GoodRx that went with that. Easy Healthcare Pre-Mom Fertility app. Here you have data that's being collected on, people's cycles, their sexual activity, very, very personal information that they say, again, they're not going to share it with anyone, but they turn around and they share it with Google and some other companies. And so, again, the FTC went after them. This was a second case where they used the health breach notification rule in the enforcement action. There, it was only a $100,000 civil penalty. That has to do a little bit with, the size of the issue and a bunch of other, situations also, or conditions also. But similarly to GoodRx, it's not just the financial penalty. You also have a bunch of other conditions that are being applied as well. And then Better Health was for online counseling and mental health. And here again, they promised to keep the information private, turned around, shared it with Facebook and Snapchat for advertising. So the FTC went after them. And not only did they share it with them, they placed no limits on how those entities can use the information. So in that case, it was $7.8 million. And that, interestingly, was the first time that the FTC included, as part of the enforcement order, that money had to be refunded to some of the customers. So in any event, all of these are just examples of be truthful to your customers. If you're going to share the data, tell the customers that you're going to share the data. If you're changing your practice and you didn't share data and you're going to share data now, don't change it retroactively, provide notice, provide seek authorization even, and then, do it on a going forward basis. The next slide is a little bit more focused on security. So the One Health situation is another FTC enforcement action. Here, they represented to the public that they used rock solid security, and they only shared the genetic testing data in very limited situations, like with someone's doctor. But in fact, the data was publicly accessible. It was even labeled by people's first names in some situations. They changed their practice and started sharing it with supermarkets and other supplement providers. And so the FTC went after them in an enforcement action. And again, part of the enforcement action was doing customer refunds. Some things to think about with AI and security issues is that if you have, people accessing data that they shouldn't, or hacking into systems, you can have misdiagnoses, you can have mistakes during AI-assisted surgeries, you can have malfunctioning of devices that have AI software as part of them. So you have some pretty scary things that can happen. And you should obviously take into account those potential security issues when determining how secure the data has to be, password protection, limiting access, encryption, all of that. Moving on to trade secret litigation. This is an area that I think is going to really be a lot bigger than it currently is. So currently, a lot of advances are protected by patents, and you have patent litigation that results. But when you have artificial intelligence, a lot of what a company's commercial advantage comes down to is the data that they're collecting, the algorithms that they're using to process that data, and some of the key takeaways that result from the processing of the data. And all of those things are more often, or in some cases only, able to be protected by trade secrets as opposed to patents. And so you're going to have an increase in companies relying on trade secrets. And then you have trade secret misappropriation claims often come up when you have an employee move from one company to another, or you have a business deal that goes bad, and you have a situation where someone had access to, highly secret confidential information, and now they're at a competitor. And they might be using that information. And so trade secret litigation, while I don't have any examples, I think it's an area that we'll see a lot of litigation for AI-related MedTech. And then the final area is tort litigation. And this includes like negligence cases, products liability cases. And here, this is going to be a big area of AI-related litigation for MedTech. And we just kind of put up some general examples of what will happen in this space. So, for example, if an AI-based medical device is trained using data from one population and then it's applied to a different population, what happens? And this is like Jen was talking about the edge cases. And also, what about the obligation to update the data? If you trained it using old data, how often do you have to update it? If there's a big medical discovery, what do you do? And so I think we're right at 3 o'clock. So I will stop, and if we have anyone that has questions, we're happy to answer.
Okay, we don't.
How is that? Can you hear me?
Yeah.
Yeah. Okay. We're right at 3 o'clock. I'm just going to ask one question of you. What are some ways that you would recommend for companies to stay on top of the latest in AI regulatory developments and updates?
So it's a whirlwind right now. It feels like a fire of information coming at you. Definitely stay in the loop within your industry, follow trade groups that are promulgating standards within your industry. Pay attention to the executive orders that are coming out. There've been a handful of this year, so it's not unmanageable. And stay on top of the news as you see, headlines coming out about the latest and worst use case of AI. Just stay on top of it. It really is a rapidly changing area in terms of new risks that are being identified. And unfortunately, it goes with the territory, given how fast a lot of the technology is changing and evolving over time.
I agree.
Thank you.
Jen, I'll just add on that just because something isn't in the medtech space, I would encourage you to read, cases that are coming out, because AI, it might be something that's far afield, like autonomous vehicles, but the results of that litigation could be very impactful in medtech as well.
Thank you both very much. Jen and Jenny, we really appreciate your time today. AI presents such novel and complex challenges for our audience, and we really appreciate your ability to break this down for us. Thank you for joining us. This concludes today's webinar.